Hello, Realtors. I'd like to welcome you to the 2.5 hours of mandatory NAR Realtor Ethics Training. This is being brought to you by the Long Island Board of Realtors. The session today is entitled, The Road to Ethics is Paved in Gold. And as I mentioned, it is a mandatory 2.5 hour course that has in the past been required every 4 years by the National Association of Realtors. But as of late, it is now a 2-year requirement. So from 2017 and on, you will need, as a member of LIBOR and the National Association of Realtors, to take a 2.5 hour ethics course every 2 years. So a good way to remember that is, being that our licenses are renewed every 2 years, you need to be sure to take the required ethics course, which again is a requirement of the National Association of Realtors, but in addition also take fair housing, which is actually a requirement of the Department of State. At this point, I would also like to introduce myself. My name is Laura Capersino. I am a New York State certified real estate instructor. I am also at the time of this recording, the immediate past president of LIBOR. I did serve as your president in 2015. I am also a member of LIBOR's Professional Standards Committee. And we're going to be touching a little bit on that today, actually quite a bit on the Professional Standards Committee aspect and how it relates to the Code of Ethics as well as arbitration. So I do have firsthand experience involved with the hearings that we will be discussing today and can provide further insight in addition to what we have required before us in the webinar. What I'd like to cover at first here is just to set a foundation and really a basis so we have an understanding of exactly where the Code of Ethics comes from and how it applies to us as realtors, and also a little difference between that realtor and the actual real estate licensee. But first, we're going to take a look at our realtor associations. Of course, we see here on the screen Long Island Board of Realtors. That is our local board, and it is referred to as the local board. And what we serve here on the Long Island Board of Realtors is Nassau, Suffolk, and Queens. Our board does have members that extend into Brooklyn, even the Hamptons and beyond, but our charter with the National Association of Realtors has us covering these 3 counties here in New York. So that is our local association. At this given time, we have nearly 21,000 members. That makes LIBOR at this time the 3rd largest realtor board in the country. Yes, we are very, very large, and we encompass a large area as well. In addition to that, the state association has approximately 51,000 members. So we see that LIBOR, the Long Island Board of Realtors, with its 21,000 members, has a large portion of membership in the state association as well. Which leads me, if you'll look at the screen here, to NYSAR, which is the New York State Association of Realtors. So we have our local board, we have our state board, and then we have, of course, the National Association of Realtors. This is the national association covering all of the country, in addition to some other territories that I will touch on in a bit. The National Association of Realtors, I'm sure you've seen, of course you know in our daily business, but you also see the commercials on television on why to choose a realtor, and the commercials also extend and promote the benefit of using a realtor. One of which is a realtor is bound by the National Association of Realtors Code of Ethics. Now, not every real estate licensee is a realtor. Right now, approximately in the state of New York, there are about 186,000 licensees. Now, those are brokers, associate brokers, and licensed real estate salespersons. So the Department of State has approximately 186,000 licensees on record, but only 51,000 of them in the state of New York are actually realtors. So not everyone is a realtor, and we do see the term being used maybe perhaps quite loosely at times, but not everyone is a realtor. We are realtors, which is something we could and should be very, very proud of, but again, not all licensees are realtors. Realtors again abide by NAR's Code of Ethics. Now here at our local board, I want to bring some clarification to this as well, because sometimes I find out in the field this is a bit misunderstood, or perhaps there's just some confusion in regard to the Long Island Board of Realtors and the Multiple Listing Service of Long Island. LIBOR and the MLSLI are two distinct organizations. LIBOR is our Realtor Trade Association, and the MLS is a corporation that offers a service to the members of the association. So they are two distinct entities. What I find happen often is a lot of our members, the realtors, do not understand or really recognize the differences. An example would be having an issue with another broker or another agent. Let's say you're having a little difficulty trying to submit an offer, you're not getting a phone call back for an appointment or whatnot. Some people feel or would say, what can LIBOR do about this? Or, I'm going to speak with LIBOR. That is not a LIBOR issue. That is actually an MLS issue. So the way to handle that would be according to the MLS rules, which are located on the Stratus website, on the main info page. There is a menu on the right side of the page, and it will say MLS rules. And if you click on there, you can save yourself a PDF of those or print them out and give them a good read. And there is a process for handling issues out in the field with other brokers and other agents. And that's why zone chairpersons are in place to handle those things. Issues that would deal with ethics, which is why we're here today, are issues that are dealt with through LIBOR, your trade association. And again, the ethics comes down from the National Association of REALTORS. So there's a difference between LIBOR and MLS. So it's important to give a good read up on the MLS rules and familiarize yourself and have an understanding of which way and what the best process is to handle any situations that you may be having. In addition, other than the Stratus website, when you go to lirealtor.com, that is the landing page before you get to Stratus and access the MLS. If you would look at the top menu bar, across there you will see that it says member areas. And if you were to click on member areas and then go to resources, there's another link to click on called Documents on Demand. Within this link, you will find the Code of Ethics. So you're able to either print it out or pull up a PDF. And if you do find the time during this seminar at this given point, or if you don't have to exit out of the screen, however you may want to work it, it would be good for you to pull up a copy of the code because we will be referring to it now and then, and it's always good to have something in front of you to reference or perhaps take notes on. If you're unable to do that, I would highly encourage you just to take notes regardless, because we will be touching on quite a few things that will affect your business and can affect your business in either a positive or unfortunately even a negative way. Now, speaking about governing our conduct, we were talking about the Code of Ethics, but here are 4 entities. These are the general entities. This isn't every aspect of governance of our activity, but these are the main things that we look at and actually that we will deal with on a daily basis. We have the federal government, as we know, governing our conduct as licensees. And that includes the Federal Trade Commission, the FCC, Federal Communications, EPA, and Fair Housing. Now, federal trade deals with the antitrust laws, of course we know, which include blockbusting, redlining, and so forth, market allocation, and so forth. FCC has to deal with the do not call registry. Do not call registry, yes, that is from the federal government that puts that out. EPA, we deal with that when we deal with the lead paint disclosures that we're to have signed by both seller and buyer, landlord and tenant. And of course, we should all be well aware of the Federal Fair Housing Act. On a more local level, we deal, of course, with the Department of State. That governs our conduct under real property law, which we find license law and agency law. If you haven't really taken a look at that, I would highly advise that you do. It's easily accessible. What you would just need to do is even just Google Department of State, New York, real property law, and the link will be right there. You could download or print out the document. It's there in a PDF. What you'll find in there, especially within Article 12A, will be advertising guidelines. There's a lot of new information, some new laws that have passed about the emergence of teams and how teams can market themselves. So it's very good for us to not only be aware of our code of ethics and locally our MLS rules, but really, realtors, it is very important to take a good look at what's in real property law. Now, as I mentioned before, we have the National Association of REALTORS, the New York State Association of REALTORs, and LIBOR, which gives us our code of ethics. And out of our code of ethics, there are also the guidelines and requirements for arbitration amongst brokers, principal brokers. And then we do have the MLSLI, as I mentioned before, the MLS rules. So as you see, there's quite a bit that we have to be aware of and be responsible for knowing and conducting business in the manner in which our conduct is governed from these entities. Now, this is something I hear quite often. Oh, why isn't LIBOR doing something about such and such a broker? They never let me in. Why isn't MLS doing something? I can't get my offer in. When it comes to enforcement in this industry, even with actually any one of the entities that we just spoke of, there isn't any ethics police department. There isn't anyone. LIBOR is not the ethics police. Neither is the MLS. The MLS rules. So it's not like we can say, call up the MLS and say, do something about this broker. There are processes in place, and we're going to be speaking about them today when it comes to ethics hearings and arbitration. Again, with the MLS, there are also processes in place to take care of certain circumstances and situations as well. So it's up to us as the individual to take advantage of what is before us, either to correct situations or bring situations to light to other people who we feel who are not following the rules and the regulations. Even the Department of State, the Department of State will investigate, but they wait for a complaint, all right? Aside from the fact that testers are sent out to look for compliance and whatnot. But other than that, they will act on a complaint. So we have that same issue, same process actually here, that if you feel there is unethical behavior by an agent or a broker, the remedy is to file a complaint and go through the process. Same thing with the MLS rules, that can be done as well. So we individually and collectively have the responsibility to uphold the law and maintain the standards of our industry. So it's on us, basically. Yes, it is. And you will be learning a lot through this session here today on how to take any steps or avoid, actually, even more importantly, avoid finding yourself in a position where someone would even file a complaint against you. So it's very important that you listen up, pay attention, and take some good notes. So what we're going to be covering here today, I'm just going to give a little outline of that so that you have a full understanding. We're going to look at the history and the background of the Code of Ethics. We're going to be looking at the preamble of the Code of Ethics. We're going to be talking about ethics in the real estate industry. We're going to look at the 3 different sections of the Code of Ethics. It is divided into 3 separate sections that are topical. We're going to look at the structure of the code, the different articles, standards of practice. We're going to talk about ethics or arbitration, which of the two, and we're going to detail both of them and the processes that are required once a complaint is filed. We're going to look at some LIBOR statistics. We're going to talk about mediation. We're going to talk about ethics, enforcement, grievance, hearings, and disciplines, as well as arbitration, how cases are initiated, the grievance process, hearings, and payment of award. Obviously, we see here arbitration does deal with the payment of a reward. So that is regarding a contractual dispute regarding commissions from broker to broker. And then we're going to talk about procuring cause versus the meeting of the minds. And this is what I always find so interesting. And what we'll do is we're going to do a breakdown and a good definition of what these two specifically mean and the role they play in regard to which broker actually has earned the commission. So let's look at the history and background of the Code of Ethics. NAR, which is the National Association of REALTORS, was formed in 1908. So the association is over 100 years old. At that time, it was first named the National Association of Real Estate Exchanges. And they had an objective in 1908, and that was to unite the real estate men of America for the purpose of effectively exerting a combined influence upon matters affecting real estate interests. At that given time, the membership for the National Association of REALTORS was 120 members, and it included 19 separate boards. Now today, the typical realtor, and this is in accordance with NAR's member survey, the typical realtor today is a 57-year-old female who is college educated and owns her own home. So we do see quite a contrast and a change from when initially the association was formed to unite the real estate men of America, to find it 100 years later that actually 58% of the members of the National Association of Realtors, more than half, are women. NAR currently has a membership of 1.2 plus million members, quite an increase from the 120 about 100 years ago. There are 54 state associations, which will also include Guam, Puerto Rico, and the Virgin Islands. There are over 1,400 local boards. And again, LIBOR falls into that local board category. And if you remember, I had mentioned earlier that LIBOR, with our approximately 21,000 members, is the 3rd largest association in the country, and that would be out of 1,400. There are actually some boards in New York State that have less than 100 members. So there are many boards, different sizes throughout the country, and they all function in accordance with the mandates, requirements, and guidelines of the National Association of Realtors. There was no license law at the time. So what first came about when the association was formed in 1908, they recognized the need to unite people to get together and just to have some sort of influence and structure on matters affecting the real estate interests. So being no license law was at that time, this is what came into play. The real estate industry had a history of speculation, exploitation. There was disorder, little chaotic perhaps. So again, the association was formed out of this need by the parties who felt to bring unity of the real estate industry in the country. So here's the history and background, again, of the code. The Code of Ethics was then adopted in 1913. So a number of years later, after the NAR was formed, a Code of Ethics was adopted. And it was to establish a professional standard of conduct. And this professional standard of conduct was across the board for all members of the National Association, exactly what we are experiencing today. It was this Code of Ethics that formed the basis for today's license laws. Now, I had mentioned before that if you would go to the Department of State's website and print out or take a look at a copy of license law, you'll see an overlapping of what are the Code of Ethics today and what is actually in license law. So that is very interesting to see. The Code of Ethics then and now required arbitration of monetary disputes between realtors. And we're going to be talking about that in detail since Article 17 of the Code of Ethics does have the requirement for arbitration over commission disputes. The realtor term was actually first used in 1916. So there's a rich history here, and a lot came out of the forming of the National Association of Realtors when those men got together back in the day to bring some unity and structure to the industry. The Code of Ethics now is published in 5 languages in addition to English. It's in Chinese, Spanish, Vietnamese, Korean, and Filipino. And you could actually find a copy of the code in each of these languages, either on our site, lirealtor.com, again, under Documents on Demand, or at the National Association of Realtors website, which for us, that is realtor.org. Not realtor.com, that is the public site, but realtor.org. This is the basis, the true basis of the Code of Ethics is the golden rule. Now, that is a term that we've all heard for decades upon decades, the golden rule, and actually it is mentioned in the preamble of the Code of Ethics. Now, what we see here on the screen is the first page, basically, of the code. Now, if you are able to print it out, or if you are able to pull up a PDF while you're viewing this and go back and forth, this would be a good reference point for you to be able to identify with what we're speaking about at this time. But other than that, you can, of course, print it out later and then go back and take a look. So the page here that is on the screen is showing the Code of Ethics and Standards of Practice of the National Association of Realtors. This first page includes the preamble, and we're going to be touching a little bit on that in the next few slides, and then moving into some of the articles within the code a little later on. So right now what we're asking ourselves is, what are ethics? And bottom line, ethics, a group of moral principles or set of values that define or direct us to the right choice. Now that certainly sounds like the way each and every one of us should be desiring to do our business, directing us to the right choice. So it's very advantageous that we have a code of ethics to be right here in black and white. It, at any given time, anyone's unsure of what to do in a situation, there is a code of ethics to direct us to the right choice. Now, the preamble. The preamble begins reading such as this, and I'm just going to read a little from it, and what you do have here on the PowerPoint are just bullet points. But the preamble starts as such. Under all is the land. Upon its wise utilization and widely allocated ownership depend the survival and growth of free institutions and of our civilization. Realtors should recognize that the interests of the nation and its citizens require the highest and best use of the land and the widest distribution of land ownership. They require the creation of adequate housing, the building of functioning sites, the development of productive industries and farms, and the preservation of a healthful environment. And then the preamble will go on to talk also more about agent behavioral aspects and dealing with the public. So let's see what we have here. Widely allocated ownership, as was mentioned, very, very important. The actual real estate industry itself and the actual land and what it is actually that we are selling and doing. The preamble also talks about to maintain and improve standards within the industry, for us to share responsibility for the integrity of the profession. And this leads me back to what I said before. We have to share that responsibility. So if we come across unethical behavior in any way, in order for us to share that responsibility, it's just right to bring it to light and file a complaint to see that these things, people are educated and that things are corrected. It's important for us to remain informed on all issues. It's important for realtors to share our experiences with others. The preamble also speaks about eliminating practices which may damage the public or discredit the profession. Okay. To urge exclusive representation of clients. Do not attempt to gain any unfair advantage over competitors. To refrain from making unsolicited comments about other practitioners. Yes, that is in the Code of Ethics, and bad-mouthing or speaking negatively about a fellow realtor is actually a potential violation of the code. Also mentioned in the preamble is that realtors deliver only an objective and professional opinion of a competitor, and only if asked. Realtor stands for competency, fairness, high integrity, and moral conduct in business relations. Also speaks of no inducement of profit, and no instruction from clients can justify departure from these ideals. And here is the golden rule of which all of this is based upon. Whatsoever ye would that others should do to you, do ye even so to them. The golden rule. So if you don't like it to happen to you, don't do it to someone else. So if we keep that kind of mindset, and if we keep the golden rule in the forefront, it'll be quite difficult to deviate from ethical conduct. Now we shall take a look at ethics in the real estate industry. Now, what do ethics actually do? Okay. Ethics protect the buying and selling public. Now, of course they do. All right. And we even know, according to agency law and the agency disclosure forms, that we are required to have signed by seller, buyer, landlord, tenant upon that first contact, right? We know all about protecting their interests. That's agency law, but it's also here within our Code of Ethics. Promote. What do ethics do? Ethics promote a competitive real estate marketplace. Ethics also enhance the integrity of the industry by far. And how? Industry codes. Again, the code of ethics. This is our industry code. If you are a realtor, you are obligated to abide by the code of ethics. How else? Company policies. Brokers often have policies within the company that also may lend to behaviors, professional behavior, of course the ethical behavior, but that's also involved company policy. And then it boils down honestly to the individual moral values. Now I don't want to speak to or against. What do they say, like this, always a bad apple in the bunch or a rotten egg or something like that. But we do come across all types of people and things, but we have to keep in the forefront knowing we're working with one another as realtors. There is a code of ethics, and there's nothing wrong with us gently and kindly reminding one another if we feel anyone is straying. Individual moral values. Now, our code of ethics is divided into 3 major sections. The first section of the code is entitled Duties to Clients and Customers. And Articles 1 through 9 in the code are directed specifically towards duties to clients and customers, and they're quite detailed. And if you have a copy there, you can take a brief look. 2, duties to the public. So Articles 10 through 14 deal with our ethical behaviors and duties towards the public. Mr. and Mrs. Homeowner, Mr. and Mrs. Landlord, buyer, tenant. And number 3, duties to realtors. These are Articles 15 to 17. And this specifically outlines how we are to treat one another, deal with one another, do business with one another for the benefit of all. So the code is broken down into 3 sections: duties to clients and customers, which is actually 9 articles, it's a big chunk there, duties to the public, and then duties to one another as realtors. I'm going to take a look at the structure of the code. And what I mean by that is how it's laid out and how it's broken down. There are articles, as I have previously mentioned, and articles are actually statements of principle. All right, this is the principle, this is the foundation. What I'll do here now is I will just read Article 1. And this is the statement for Article 1. When representing, again, remember, the Article 1 falls under the first section, which is duties to clients and customers. Article 1, when representing a buyer, seller, landlord, tenant, or other client as an agent, realtors pledge themselves to protect and promote the interests of their client. This obligation to the client is primary, but it does not relieve realtors of their obligation to treat all parties honestly. When serving a buyer, seller, landlord, tenant, or other party in a non-agency capacity, realtors remain obligated to treat all parties honestly. And what this is referring to, it sounds very much like our agency disclosure form. This is talking about our client. The obligation to the client is primary, but our obligation to anyone in a non-agency capacity, such as a customer, we remain obligated to treat honestly. Sounds a lot like the agency disclosure. So we have statements of principle, and then within an article, there are standards of practice, SOP. Standards of practice, they support, they interpret, and they amplify the articles under which they are stated. So I read Article 1 to you, and we got the gist of what that is. So now I will read a standard of practice or two within Article 1. I will read Standard of Practice 1-3, meaning Standard of Practice 1 for Article 1-3. It is the third listed Standard of Practice. And it reads, Realtors, in attempting to secure a listing, shall not deliberately mislead the owner as to market value. What I've heard prior, being of course out in the field working myself, as a full-time associate broker, doing transactions, going on listing appointments. And I know oftentimes we hear, oh, that agent went in and gave a high price just so they can get the listing. I think that's a common comment that we hear when at any time during business. What I've adopted to do, and I've heard what others have done as well, is have a copy of the Code of Ethics with you when you are interacting with customers and clients. You could even have a copy of the Code of Ethics with you when you're on a listing appointment. And when you're discussing the price with them, let them know that you abide by the Code of Ethics and that you would not deliberately mislead Mr. and Mrs. Homeowner as to the market value of the property. You can hand them a copy of the code, highlight that section. All right, educate the homeowner. So I've heard people doing that, and I've even whipped that out a couple of times myself there. Just to speak a little more to my own character and how I do business, as well as any realtor actually should. So that is an example of one standard of practice under Article 1. Here is another. This is Standard of Practice 1-6. Realtors shall submit offers and counter-offers objectively and as quickly as possible. Okay, objectively means objectively and nothing else, honestly, and as quickly as possible. We have that obligation. It is also a requirement through the Department of State that all offers are submitted immediately as well. And honestly, it's also in our MLS rules. So it's not up to any agent to receive an offer and not submit it as quickly as possible, immediately, or within any sincere, reasonable amount of time. That could be like a triple whammy potential violation. Let me just see one other one, perhaps, under Article 1. Standard of Practice 1-16. Realtors shall not access or use or permit or enable others to access or use listed or managed property on terms or conditions other than those authorized by the owner or the seller. That would speak to the fact that you actually really do read and fully understand the listing agreement that the seller or landlord is signing with you and or your broker, and that you do not operate outside of those terms and within that agreement. And that can be extended to other things as well, but that's just an example of some standards of practice in Article 1, which falls under the category of duties to clients and customers. There are also case interpretations that are provided by the National Association of REALTORS, And those are specific fact situations to which the articles or standards of practices are applied. So it'll give scenarios on which how they are applied, and the standard of practice is in place to interpret and support, as well as the case interpretations, to provide a fuller or greater understanding of the actual article if need be. Now, if anyone was to be if anyone's to file a complaint, only articles can be violated. All right, so if someone is filing a complaint, they can't say that they did not follow standard of practice 1-3. Only the actual article itself can be named. All right, which again in Article 1 speaks about full representation of the client and honest dealings towards the non-agency party, the customer. So only articles can be cited. Okay, articles can be violated. Standards can be cited to back up and provide support. We're going to be talking more about the complaints, the filing of them, and whatnot. So now let's take a quick look at ethics or arbitration. Ethics. The basic issue with ethics, and again we're talking about ethics and arbitration because when it comes down to it, if complaints are filed, they are either ethics or arbitration, or you go through one and then you go through the other. Okay, so they are distinct, so we're going to be looking at each one individually. So ethics, what is a basic issue when it comes to an ethics complaint? This is a conduct case. And what is asked is there a possible violation of the code of ethics? Now we would only know what a possible violation of the code of ethics would be if we were familiar with the code of ethics. So again, I highly encourage that you take a look through, print out a copy, keep it, read it, understand it, highlight it, educate people with it. It's only going to better your business and better those that you're working with. So, basic issue. Is this a conduct case? Is there a possible violation of the code of ethics? Now, arbitration. The basic issue in arbitration is there a money dispute? Typically, a dispute over which realtor is entitled to the cooperative commission in a transaction. And yes, that is a commission dispute, and it happens, we know it does, and disputes can arise over whose buyer is it, whose seller is it, and so on and so on. So what we see with this, the difference between the two, ethics is conduct, okay? Could there be a possible violation of the code? Any of the articles within the code. Arbitration, is there a dispute over monies? Is there a dispute over a commission? And that needs to be from broker to broker, because as we know, any commissions paid go to the broker in turn pays the associate broker or the salesperson. So an arbitration issue can only be between the principal broker and principal broker. All right, so the broker needs to be on that, and the one filing a complaint, the complainant or the respondent on that. So we see the difference between. Now, I've been mentioning there are guidelines. I've been mentioning National Association of REALTORs. A lot of people I hear also, again, out in the field is, oh, LIBOR wants us to do this, or LIBOR says that. Actually, LIBOR is saying what the National Association of REALTORs is saying, because that's where the guidelines come from. So guidelines are outlined in the NAR Code of Ethics and Arbitration Manual. It is published annually by the National Association. It is technically, what we have up on the screen here is I have a copy of a book that I had from 2010. At our last training session for professional standards, they didn't hand out the book anymore. It was I'd have to say, close to 2 inches thick, an inch and a half, 2 inches thick, spiral bound book of guidelines on ethics and arbitration and how to go through hearings and reprimands and awards and whatnot. It is available online now through, as I mentioned before, realtor.org. All right, so there's a book that's put out. Every year it is updated should there be any changes to the code or any of the processes and guidelines. There is something new at this given time that NAR is asking, actually requiring, of all the associations that are members, all the realtor associations, and it was to be implemented January 1st of 2016, and it is an ombudsman program. And this program is designed to perhaps alleviate hearings and going the full route with a complaint, either ethics or arbitration. And what the ombudsman does is, these are trained individuals. Here at LIBOR, actually, they are the same people as are trained and skilled mediators. What they would do is this is if both parties agree, is to be the go-between and try to resolve a situation, perhaps before it would, like I said, go further to an actual formal hearing. So what would happen if this method would be chosen by two disputing parties is the ombudsman, who acts as an intermediary, would speak over the phone one at a time, basically with both parties, hear both sides, not offer opinion, but perhaps come up with some sort of resolution and a common ground on which this situation can be resolved. The individual does not provide advice and of course no personal insight into it. Now this would be a non-binding situation because either of the disputing parties can still file a complaint if they so choose to. It differs from mediation, of which we will touch on, is that being it is non-binding, with mediation there would be a resolution that would be in writing that both parties would sign and agree to carry out. All right. With the ombudsman program, a member of the public, yes, meaning Mr. and Mrs. homeowner, landlord, tenant, buyer, can actually contact LIBOR with their complaint and look to have it resolved through this process. So it's not only for agent to agent, broker to broker, broker to agent, but it's also for the public. And this way they can get more involved. LIBOR does get phone calls from, of course, members of the public that feel wronged in some way, and this process is offered to them, as well as mediation, and also going all the way to the formal ethics hearing if it is found that an article of the code could possibly have been violated. So if the ombudsman program does not work or it's not chosen, mediation is offered, and mediation is again by a trained mediator, and this is a face-to-face session where both parties air their grievances, and if an agreement can be made, it is something that is put in writing and signed by both parties, and they both agree to carry out. But if it is not resolved in mediation, or if the mediation is not a selected process, then the complaint goes to the grievance committee here at LIBOR, and we're going to touch on that process. But if a potential violation is viewed, or an article, if it's ethics, an article, the potential violation of a specific article or more than one article, then it goes to a hearing panel. And again, we'll be touching on those as well. And hearing panels can hear either ethics or arbitration cases. to take a quick look here at some statistics at LIBOR so you can just get an idea of what our professional standards department here, the staff here at LIBOR deals with, as well as the committee, Professional Standards Committee at LIBOR. Now, I do want to mention that any of the committees at LIBOR are open to all members, of which you are, as a member of the Long Island Board of Realtors. And if you would like to get involved with the Professional Standards Committee, you most certainly can. There are a few prerequisites, such as first serving on the Grievance Committee. And prior to serving on the Grievance Committee here at LIBOR, you would need to have at least served on another LIBOR committee for 1 year. If you'd like information on how to get involved with any committee, and especially perhaps lead yourself to the Professional Standards Committee, where you would have the ability to be sitting on the hearing panels, whether ethics or arbitration. If so interested, you can find that information on lirealtor.com. You can search for committees, and it will let you know how you can sign up and then be appointed. LIBOR is always looking for members to come forward and to give of themselves, actually, and participate for the betterment of the association. So let's take a look at some statistics here at LIBOR. For the purpose of this webinar, I had asked for the statistics here at LIBOR for 2015. So at whatever given time that you are listening to this webinar, these numbers are for the year 2015. Mediations heard. There were only 9 mediation hearings that were heard. 3 of them were settled, and 4 were actually terminated. So at that point, there were still 2 that are in the process and being carried over. But only 9 mediation hearings. That's not many at all, considering we're a board of 21,000 and across 3 counties. Now, arbitrations that were initiated. Now remember, arbitrations are monetary disputes over who is entitled to the commission. So there were 28 arbitrations that were initiated. That means paperwork was filed here at LIBOR to initiate an arbitration, the arbitration process. 28. Now 12 of them were heard in 2015. 1 was withdrawn. Okay. Ethics, 72. We're getting a bigger number here. And remember, ethics has to deal with conduct. All right, and would be any potential violation of any of the 17 articles within the Code of Ethics. So 72 ethics complaints were filed in 2015. 24 of them were heard, 8 of them were withdrawn. So when it mentions here that they were heard, like arbitrations heard and ethics heard, that means there was actually the formal hearing, and that's where the members of the Professional Standards Committee come in, and they are seated on that panel. And I will touch on the process in a bit, and do make the decision on whether there was an actual violation of the Code of Ethics or who should be awarded the commission. It's quite interesting. Now, mediation. We mentioned ombudsman, and then I also had mentioned mediation, and this again is a voluntary process. Now, mediation can occur before or after the grievance committee reviews a complaint. Complaint comes down to LIBOR. Let's even backtrack from that a little bit and go back to lirealtor.com and into the member services, resources, documents on demand. That's where anyone can find the forms in order to initiate a complaint. All the instructions are there. whether it's ethics or arbitration. Everything is outlined on how it needs to be done. If someone is filing a complaint, print out the documents, provide all what is required, fill out all of the information, and it gets sent to LIBOR, and it is reviewed and will go before the grievance committee, and they review the complaint. However, mediation can occur before or after, so this part can be bypassed. Disputing parties meet with a mediator appointed by the association to create a mutually acceptable resolution of dispute. And I did mention this. If the dispute is resolved in the mediation process, the parties sign an agreement that spell out the terms of the settlement. And hopefully then everyone goes on their merry way, and then there was no need for the formal hearing. Ethics enforcement. We're going to be looking at the ethics aspect, and then we are going to be looking at arbitration. They're the same, but they're different, and I will point out the differences in the process. Okay. Who can file an ethics complaint? The complainant can be a realtor, or again, a member of the public. Be a member of the public. The respondent is always a realtor. Has to be a realtor. If it's, and again, the Code of Ethics comes from the National Association of REALTORS. So if you're doing a business transaction, if you have an accepted offer on your listing from a non-member of LIBOR, or a non-member of the National Association of REALTORS. See, it could be somebody, let's say, from the Staten Island Board of REALTORS. They are also a realtor. They have the same code of ethics. If there was a complaint to be filed, it would be determined where it would actually be heard, because there's two boards involved, but they are both realtor boards. But if you are getting involved in a transaction with a non-realtor member, that individual is not obligated, number one, to follow or abide by our code of ethics. They're not bound by them at all. And remember, Article 17 within our code deals with the obligation to arbitrate should there be a commission dispute. If you're dealing with somebody, again, in a transaction that is a non-realtor member, that obligation to arbitrate does not apply to that broker. So you should be, put it this way, aware of the fact of them being a non-realtor member. Now, also available, let's get back to that documents on demand. There is a co-broke agreement that was drafted by legal counsel, Kathy Nolan, here at the board. And this co-broke agreement, it's highly advised, of course, run everything by your broker and or manager to be sure that's how they'd like for you to practice. But this co-broke agreement is designed, again, specifically when dealing with non-realtor members. It speaks about the code of ethics, and it speaks about an obligation to arbitrate. And not only is it a co-broke agreement, which details the amount of commission to be paid to that cooperating non-realtor member, but it also mentions the code of ethics and the obligation to arbitrate, and they sign this to agree to abide by it. And when you think about it, even Article 1 of our code, which deals with duties to the public and us having the primary interest for our client, wouldn't you say it is in the best interest of your client to be sure that whoever is involved in the transaction, whatever other agent is involved in the transaction, is also abiding by the same code and rules to arbitrate? So please look into the documents on demand again. Give that a good read, show it to your manager or your broker, and begin to consider or utilize this form, because not only is it for your broker's protection, but also, honestly, for the client. Also for the client. So that's an interesting factor there. So be sure to look that up and print that one out as well. A complaint must be filed within 180 days from the time known or reasonably should have known that the potential unethical conduct took place. This is going to go back to, if you feel you're doing wrong or something's not going right with the deal, document everything. And I'm sure this is something that your brokers and managers can tell you all the time anyway. Phone calls, if things are starting to get a little tough, a little sketchy, you're not feeling easy about perhaps that being treated fairly or in an ethical manner, begin to document these things. Because if it does get to a point where a complaint should be filed, if things escalate, it must be filed within 180 days from the time known or when you reasonably should have known that that potential unethical conduct took place. So I hear often enough, oh, now that I look at it or now that I see it, I could file a complaint on from this issue. Look how these things turned out. And it would be, well, when did this happen? Well, it was about a year ago. Well, you know what? It's just a bit too late. So it's very important that these issues are acted on in a timely basis and record is kept of once you feel things aren't going right, that you do keep a detailed record. So there's 180 days to file. Now here's the grievance committee's role when it comes to the review of an ethics complaint. The grievance committee is actually a screening committee that's comprised of members of LIBOR, and they are appointed and they're put on this committee, on the grievance committee. They meet, I believe it is at this time, they meet on a monthly basis. And it's not the same people every month because it's a very large committee. Otherwise, sometimes it can be a bit much. But they meet and they review the ethics complaints that have been submitted to the board. And that is what their responsibility is to do, is to review, simply review. During this review process, this is what they're asking themselves in regard to any particular complaint. If the allegations in the complaint were taken as true on their face, is it possible that a violation of the code of ethics has occurred? Okay, so what that specifically means is true on their face as it was written. It is not this committee's job to dig, to undiscover, to research, to ask. It is what has been sent in black and white. Is there enough here? Is there enough here for us to actually say there is a possible violation of the code? If the committee says, yes, there is, the case goes to a hearing panel. If the committee feels, no, there is not, then the case is dismissed without a hearing. There can be an appeal to that if the complaining party feels it should be so. There is an appeal process. However, again, the information that the committee is reviewing is the complaint that has been submitted. And I hope you recall that earlier on I had mentioned that potential violations could only be named on specific articles. So a complaint cannot be submitted and said, I think that so-and-so broker did not submit my offer on a timely basis and therefore they are unethical. that statement is not in direct correlation to an article. So a specific article would need to be pulled out and identified within that and named. And it can be more than one article. There could be a series of instances or behaviors or actions that are deemed to possibly be unethical. And therefore, the person filing the complaint, upon reviewing the code of ethics that we all should be familiar with, can look and say, wow, you know what? There is an Article 1 violation here. There definitely is. But I also do see that there might be an Article 4 violation, and maybe even Article 10 might be able to be pulled into this, all right? And that's what the committee looks at, the actual complaint and the direct correlation to the article or articles. Now, if it does go, if the committee says yes, there could be a potential violation here, it goes to a professional standards hearing panel. This panel is comprised of members of the Professional Standards Committee. Oh, and I do want to mention the Professional Standards Committee, of which out of that committee come the Grievance Committee members. We are required by the National Association of REALTORS to undergo annual training. And it is a day of training. We have it held here at LIBOR's main facility in West Babylon. If I myself, as a member of that committee and want to serve for that year, and I am unable to attend the professional standards training at LIBOR, let's say if I'm unavailable that day, I must take it somewhere else. And it's given at different boards, you know, throughout the state. And I may find myself in Rochester having to take it, because you cannot serve on the committee without the annual training. So the members of the Professional Standards Committee that are a part of Grievance and sit on these panels are thoroughly trained on an annual basis and are not permitted, as per NAR, to serve without having gone through the training. So it is a very serious matter, serious issue. And so just rest assured, those that are on these committees are people who are highly trained. Okay, the hearing panel to conduct a full due process hearing with sworn testimony, witnesses, and evidence. This hearing panel decides whether there was a proven violation of the Code of Ethics. And this, and I have it underlined here for a reason. And when it comes to ethics, there are different determining factors between ethics hearing, an ethics hearing, and an arbitration hearing. When it comes to ethics, it needs to be proven by clear, strong, and convincing proof. The evidence presented at that hearing must cause each panel member to see by clear, strong, and convincing proof. Like, in other words, yeah, you convinced me there is a potential violation here. I see it. That's how heavily the evidence, testimony, witnesses, and whatnot weighed in. It's not 50-50, maybe so. No, clear, strong, and convincing. A findings of fact is a written narrative of what have occurred. Now, in the panel hearing, in that room, and they are currently conducted at the West Babylon LIBOR main office in a conference room, and who is present at the hearing is the panel chairperson, who of course is a member of the Professional Standards Committee, trained chair. Okay. There are 4 panel members. There is LIBOR counsel present, and it is LIBOR counsel who draws up the findings of fact, which is a written narrative of what has occurred. There is also a staff member, again, highly trained staff member from the Long Island Board of Realtors, who is beyond well-versed in all of the regulations of ethics arbitration panels and what can and cannot be done. The hearing is recorded, and the board is required to tape every proceeding. What is allowed now is remote testimony. That's if somebody could not be present, but this remote testimony needs to be done at another board, a secure, confidential place where someone who could not attend the hearing is testifying from in a Skype type of method. All right, so in that room, it's a conference room, large conference table. We have the chairperson, the 4 panel members, LIBOR counsel, and LIBOR staff present. Then there's the complainant, the person who's filing the complaint. That person can have witnesses. They can even bring an attorney if they so choose. Okay. And then there's the respondent, and that individual can also bring along witnesses if they so choose. It is the panel that determines the discipline to be imposed on the violator or the respondent. And this happens through what is referred to as an executive session. After the panel has completed, everything is done, the parties, the complainant and the respondent, are dismissed from the room, and then the panel goes into executive session to review what has happened during the hearing, and then they determine the discipline to be imposed or perhaps not. Ethics, standard of proof. And I did touch on this a little bit, but can still want to drive it home. Here we go. Clear, strong, and convincing shall be the standard of proof by which alleged violations of the Code of Ethics are determined. Clear, strong, and convincing shall be defined as that measure or degree of proof which will produce a firm belief or conviction as to the allegations sought to be established. So again, the panelists that are sitting in on an ethics hearing need to be clearly, strongly, and absolutely convinced by the testimony and the evidence that was submitted that there was, as appears, a violation of the Code of Ethics. All right. So these cases, interestingly enough, really can, they get detailed in and of themselves because it is up to that complainant to really produce evidence and a case that is clear, strong, and convincing. That's pretty heavy. It's not like a jury where, you get the majority number perhaps and whatnot, but everyone on that panel needs to really have a firm belief. Yes, with everything that was presented, we have an issue here. So ethics enforcement, there is authorized discipline. And again, this is coming from the National Association of Realtors. The NAR sets what the disciplines are for a violation. If you're found in violation of any one of the articles of the Code of Ethics. And here's what they are. A letter of warning. Okay, now please make note that this letter of warning gets sent to you, gets sent to the violator. I don't want to say you. A letter of warning gets sent, and a copy of that letter is placed in the member's file. Yes, there is a file. And we will touch on why there is a file. Okay, so the lower, we're going from the lowest level of a discipline up to the highest level of discipline as authorized by the National Association of REALTORS. You can get a letter of warning. This could be an issue where I really didn't mean it, and you know, and it seems like it could be a sincere mistake, but they did violate the code. Let's just give them a letter of warning. Then there's a letter of reprimand, just getting a little bit stronger at this given time. And this also is placed in the member's file. What could also be required is education. It's a requirement that the member attends an ethic portion of a board indoctrination course or other appropriate course or seminar specified by the hearing panel, in which they can reasonably take into consideration with cost, location, and duration. We actually have a number of courses that are come out as part of the discipline required to take, one of which is, you have to love the title, Kathy Nolan's course entitled, Don't You Wish You Hadn't Done That? That's the one a lot of people end up getting sent to. It has to deal with ethics and just minding your P's and Q's and being sure that you're aware of what you've done and how not to do it again. Also, these disciplines can be combined. There could be a letter of warning and education, and so on. First offense. Not to exceed $5,000. So NAR allows for up to the first offense. Somebody could be fined $5,000 for your first offense. Okay. This gets a little heavier, and this is also new, which just came out of the prior National Association of REALTORS board meeting. The board of directors had voted on this, and it was passed, that the second offense, second plus, second, third, and up, you can be fined up to $15,000. So this where it comes into play about the member file. If you receive a letter of warning, and then another letter of warning, a couple of education classes, and you still haven't taken heed, or the potential violator, the violator actually at this point, because they would have been found in violation, has not taken heed, the panel, if it's not being their first offense, can actually authorize a discipline of up to $15,000. In all fairness, due process, and how the panel and the decision making works is, as I mentioned before, the complainant and the respondent, the one filing the complaint and the one being accused, after all testimony is given, they've had an opportunity to speak their piece, be questioned by the panel, and with nothing further, they are dismissed. Again, it's the executive session that takes place. What is discussed at that given time amongst the panel members is only the case at hand. The testimony, the evidence, everything that was presented during that given hearing. If it's strong, clear, and convincing, just on the articles, or whatever it was the specific complaint was, if they're found or deemed to be in violation, that is the decision the panel makes at that given time. The panel is not privy to the member's file. The panel does not know at that time if that person is a repeat offender. So what is judged at that particular hearing is if that violation, whatever was in the complaint, the violations did occur. If the panel feels they're strongly convinced and have firm belief that violations of the articles that were noted did take place, a vote is taken. If it passes, then what happens is it's noted, of course, in the findings of fact, which are taken by the counsel that is in the room. Then the member's file is open for consideration when it comes to determining the discipline. So it's at that time that that panel gets to see if this person has been, this individual has been, has a repeat or a history of this unethical behavior. And that's when they can determine, well, you know what, this individual, you know, he's had repeated letters of warning, attended the classes, this is the third offense. They can actually say he will be fined. We recommend a fine. We recommend a letter of reprimand, education, and a fine of $15,000. All right. This is very serious. And the National Association of REALTORS had increased the amount recently to $15,000. And this came out of, you see, at the national level, they also have committees there, and they have their own professional standards committee that hears from state associations and who hears from local associations. So basically the decision that is made by the National Association of REALTORS when it came for the recommendation from the professional standards committee at that level to increase this, it came before the board of directors of the National Association of REALTORS, which I believe there are somewhere upwards of 800 directors in the room. I am privileged at this time to be one of them and be there twice a year for these meetings. They voted to increase this fine because it was recognized throughout the country that there is a need for more of a firmer discipline for perhaps in all hopes that realtors will get in line and behave and conduct business in a more ethical manner. So that's why it was just recently increased to the $15,000 for second and beyond offenses. Next, it could even be, and again, this can be a combination, suspension for not less than 30 days or more than a year. Okay? Membership of that individual can be suspended. Membership from the association. Also, expulsion. In other words, you're out. Okay? And this would definitely only come, honestly and sincerely, a panel would only go to this level if it is somebody who has a history. Okay? So I want to bring this up. Now, we know we're all out working, we're out in our markets, in our area, and if there is a, I don't want to seem like I'm accusing or pointing any fingers in any way and anything, but just talking about any given circumstance. If there is a broker who you have had experience with prior with unethical behavior and you know it, but you don't say something, and they get to carry on in this manner, which is not in the best interest of their client, which is what it will boil down to. So if you're not saying anything, or the next broker's not saying anything, and it's, and it's been going on, and then maybe finally one person does file a complaint, but there is nothing in this person's membership file that they have been a repeat violator, to be punished to a degree that would maybe cause them to say, hey, wait a second, you know, this is not right for me to be conducting my business this way. I'm being called out on it, and I better shape up. But if nobody is saying anything or following through with the process or allowing the process to work, then that's why people will continue to get away with what they do. So I'm mentioning this is because if you really feel wrong, you know it was unethical conduct, make the complaint, go through the process. Perhaps in enough time, 1, 2, 3, 4, enough people do this, or even you do it enough, $15,000 will be slapped onto this individual as a discipline. Maybe they will begin to think twice and then look at the next level, suspension, expulsion, you know, and so on. Okay, there can be a suspension or termination even of the MLS privileges, which would harm their business. So it's very important. You know, you can hear people on the sidelines, oh, so-and-so. Meanwhile, I might want to remind you, it's been unethical to be speaking negatively about a fellow realtor anyway. So be careful out there. Okay, you don't want to be found unethical behavior while you're speaking about someone else being unethical. But the thing is, if you see a pattern, just do something about it. Let the process work. Let the system work. Let the individual be held accountable for any unethical behaviors. We are all realtors, and we're supposed to be working all with one another, towards the public, under one certain code. I'm going to go into the arbitration aspect, and I did mention already that ethics, they're the same but different. Same panel process, same manner of filing the complaint, same manner of going through a grievance committee, but there are different determining factors on how the outcome, the panel comes up with the outcome when it comes to arbitration. Again, ethics is based on conduct, and an arbitration hearing, an arbitration complaint is based on a monetary dispute, basically of any commissions that may be due to a cooperating broker. So let's take a look. Who can file an arbitration hearing? File for a hearing, file a complaint. When it comes to arbitration, has to be a realtor, okay, because again, these are under our code of ethics. Arbitration falls under Article 17, okay. A realtor principal, that's broker owner or the principal, against the respondent, also has to be the principal. Why? Because the law indicates that only a broker can be paid a commission for a real estate transaction. The broker, in turn, can pay commissions due the licensees that are underneath their supervision and affiliated with them. An agent cannot file a commission dispute, an arbitration hearing against another broker, because that agent is not supposed to be paid any commissions, even direct, even if it was awarded to that person. So it just does not work that way. So highly advised, and I'm sure all do follow this practice anyway. If at any time during the transaction in any way you're feeling that the commission is in jeopardy, the commission is in jeopardy. All right, again, you document any and all things and notify your broker. I was just going to give a scenario, but I think we'll be touching on this in a few slides anyway. So it's important here to know arbitration, commission dispute, principal broker. Here is the process. A request is filed. Where do you get the paperwork? On lirealtor.com under Documents on Demand. All of the forms are there with complete instruction. Now, arbitration is conducted, as I mentioned, under Article 17 of the Code of Ethics and also by the state arbitration statute. Ethics is not part of this hearing. This is a hearing that is basically just being heard on the fact of a complaint that a broker feels a commission was due that they did not get paid. It is a monetary dispute. Code of Ethics articles are not named here. That is not the purpose of this hearing. So it is different. So ethics is not a part of it. Can the person have been involved in unethical behavior? Absolutely. But it's not part of an arbitration hearing. Article 17 provides that arbitration occurs under these following circumstances. Contractual disputes or specific non-contractual disputes. So that is found in Standard of Practice 17.4, which means it's Article 17, Standard of Practice 4. And honestly, it is quite lengthy, and it's not something that I would take on to read at this point, but it does Standard of Practices. Again, what do? They interpret and they support the article. And Article 17, in and of itself, that I will read briefly. The first paragraph says, in the event of contractual disputes or specific non-contractual disputes as defined in Standard of Practice 17.4 between realtors, principals associated with different firms arising out of their relationship as realtors, the realtors shall mediate the dispute if the board requires its members to mediate. Here at LIBOR, mediation is voluntary. If the dispute is not resolved through mediation, or if mediation is not required, realtors shall submit the dispute to arbitration in accordance with the policies of the board, rather than litigate the matter. So what Article 17 is indicating here, there is an obligation to go to arbitration, not to court, all right? And this brings me back to what I was saying before. When you're dealing in a transaction, going to contract in a transaction with a non-realtor member, if there is a commission dispute, that non-realtor member is not obligated under Article 17, which gives the pointing out the fact that you need to go to arbitration and not litigate. So it can end up in court. Not a happy situation, not for your broker, not for any broker. All right, so again, go into Documents on Demand, pull out that co-broke agreement that was drawn up by the council here at LIBOR for your protection and the protection of your clients. So be sure to take a look at that. So it has to deal with contractual disputes or specific non-contractual. Between realtor principals associated with different firms. You can't fight an arbitration within your own company. That's a matter between you and your broker. Okay, and it arises out of relationships, as I read, as realtors. So it's a realtor-realtor. Again, with a non-realtor, there's no obligation for them to sit at LIBOR in an arbitration hearing, unless they signed off that they would on a co-broke agreement, should there be a matter of dispute. Now, arbitration also goes through the grievance committee. Here they are again. And they perform a screening function to review all of the complaints, same as with the ethics. Now remember, the ethics grievance committee is looking to see if there could be a potential violation of any of the given articles. All right, remember, ethics is not part of arbitration. So this is the key question that the grievance committee asks itself when reviewing complaints for arbitration. And that key question is, If the allegations were taken as true on their face, is the matter related to a real estate transaction, and is it properly arbitrable? Is there some basis on which an award could be based? So what the grievance committee is looking at here is when your complaint comes in, they're taking a look. Again, they're not going to be looking at any articles for the Code of Ethics, but they're going to take a look here at what was written in black and white. And that's the meaning here of allegations were taken as true on their face, as what is written. Okay? Is that matter really related to a real estate transaction? Okay, because it could be some other issue. All right. Can this be arbitrated? Can this go to a hearing? Can an award be based on this information? And what is the award? The award is who is the one who gets the commission. And going to an arbitration hearing panel, whatever that panel decides is what it is. And they're not there to split either and say, well, we have X amount of commission here. Let's give half to that one and half to that one. And I think that, no, it's all or nothing. So when you're going for an arbitration hearing, it's all or nothing. So it's best have your ducks in a row. Again, document when you feel things are going south, when you feel things are a little fishy, whatever it may be. Start writing everything down. Hopefully everybody has their proper forms, their agency, their lead, their listing agreements, their buyer broker agreements, everything. Now, arbitration, as it goes to the professional standards hearing panel. This again consists of members from the Professional Standards Committee. They are to conduct a full due process hearing with sworn testimony, counsel, witnesses, and documentary evidence. The panel decides which realtor is entitled to the award, typically a disputed commission in a transaction, which is proven by a preponderance of the evidence. And here is another aspect where it differs from ethics. Remember, in an ethics hearing, the panel needs to have been clearly and strongly convinced and have a firm belief that that party, the accused, has violated one of the articles. Here, when it comes to the dispute over money, it needs to be proven by a preponderance of the evidence. Also, what's taken into account heavily is procuring cause versus meeting of the minds. Now, the payment of the award. Okay, the panel goes through. They say we're going to the commission goes to the complainant. The commission stays there. So this award can actually be judicially enforced if it's not paid by the non-prevailing party. Very interesting. Okay. Some associations require that the award, meaning the commission and the money, be deposited with the association pending review of the hearing process or during a legal challenge. But let's take again a look at that standard of proof by which this panel comes to their decision. The standard of proof on which an arbitration hearing decision is based shall be a preponderance of the evidence. And preponderance of the evidence shall be defined as evidence which is of greater weight or more convincing than the evidence which is offered in opposition to it. That is evidence which as a whole shows that the facts sought to be proved are more probable than not. So you see, there is a big difference here between the preponderance of the evidence as opposed to clear, strong, and convincing. Like without a doubt, I firmly believe. And that's what happens with ethics. Here, with the evidence that is presented, it's just a matter of which party's evidence, testimony, witnesses, and whatnot carries more weight. See, it's got to go one way or the other. So those monies are going to either go to one party or the other, stay where they are, get paid to the other, or whatever. So it's a matter of whose evidence shows to be a little more stronger, to the point that they're more probable than not. So that could be like, okay, 51% to 49%. All right, so it's different. So, and it's something else, because when this comes to money, this can be tens of, oh my goodness, how much money this could be, right? So again, if you feel at any given time that something is not going right, or a commission due is going to be in jeopardy, begin to document everything. Have everything in place. Because when you're sitting at this type of hearing, you don't want to be the person coming up with your evidence not carrying enough weight. You don't want to be the one that might be 49% believable, but you know what? The other guy is 51%. So it's more probable than not we are going to award to that party. Now, what's really interesting about these type of cases is, more often than not, they arise out of the good old, well, whose buyer is it anyway? That's my buyer. No, it's my buyer. All right. Well, nobody owns a buyer that we know. Okay. If a buyer signed an exclusive buyer agency agreement, they've committed themselves contractually to pay that broker, whether they use that broker or not. So that's a little bit of a different story. But if we look at a scenario such as an open house, a public open house, if an open house is put on the multiple listing service and it's on the website and it goes up through ListHub and it goes to Zillow and it goes to Trulia and it's in the newspaper, should you so choose to use any paper or magazine to advertise your open houses, and a buyer walks into that open house, that does not make that buyer the listing agent's buyer. Even if they showed the buyer through the entire property, spent a half an hour telling them how wonderful the new electrical and plumbing is, it does not make that buyer the listing agent's buyer. And I do want to mention this, as a matter of fact, anyway, doing an open house, it is beyond wise and perhaps lawful to actually have the agency disclosure forms there. Because if you're going to be discussing anything with any potential buyer that is beyond the four corners of the flyer that you have given out to them at that property when showing it, you need to be giving them that form, and it needs to be disclosed that you're working for that seller. And the whole purpose for agency law when it came about was to protect the consumer. It's not for a real estate licensee to claim a buyer because they checked a form. One thing honestly has nothing to do with the other. One is disclosure. Okay. Now with the disclosure, you need to disclose that you're working for that seller, to that customer buyer that came walking into that property. Now that buyer, as a member of the public, a consumer, has the right to representation. They have a right to choose to be represented in a real estate transaction. And a listing broker cannot say that buyer is mine when that buyer has the right to their own representation. Now, it would be a different story if you took the buyer through the house, you disclosed to the buyer that you work for the seller, they signed the agency disclosure form, they decided to put in an offer, you wrote up the offer, you submitted the offer to the owner, the offer got accepted, which now we have meeting of the minds, okay? Then things are a little bit far along the process. However, nothing is black and white, because the entire process of from when a buyer began looking and how they began looking and why they're looking and what's happening is looked into in an arbitration hearing. So important, once again, if you're working with a buyer and you're working with that buyer as a customer and you're a broker's agent, please document when you begin working with them, have that agency disclosure form done. If you are unable to go with your buyer customer or buyer client to an open house, safeguard yourself, offer professional courtesy, contact the listing broker, and say, Jane Doe, who I've been working with, is going to be coming by to your public open house. There's nothing wrong with that. It's a public open house. Anybody can come and go. All right? So that's just a professional courtesy tip to do, and it'll avoid issues down the line with anybody trying to look to claim a buyer. There can be situations where the buyer truly was working with you. You sent that buyer to the open house. They knew about that open house because of you. You were unable to go, maybe because you were doing your own open house. Whatever the case may be, they went in. Listing agent could have perhaps done a little coercion. If you want to put in an offer, you got to put that offer in through me now. Your agent is not here. The buyer has a right to representation, okay? And then the buyer comes to you and says, I made an offer, and you come back in and say, well, listen, I've sent them there. I've been working with them. I have everything documented. And the listing agent may say, well, no, too bad. I mean, now it's a point where, do you think commission's in jeopardy? I think it may be in jeopardy. So who's going to be the person who's going to perhaps step up? And I'm talking about like a case scenario, and say, well, I don't want to bring harm to this deal in any way. If I'm a broker's agent, I owe fair and honest dealings to this customer, but I also, owe duties to the seller and the listing broker. So what I will do at this point is I will step out of the way, because I do not want to be a hindrance to this. And I have all my information documented that I've been working with this buyer, and the buyer wants to continue working with me, but I'm not being permitted to. And then you file, after it closes, you can file a complaint for arbitration that you were due that commission. And that's just like a scenario. I'm not saying it's black and white and who's going to win or anything like that, because it all depends on the evidence that is submitted, and it depends on from both parties and the decision of the hearing panel. Nobody knows how it's going to come out. Is it a case that can be arbitrated? Is it a situation? Yes, it can. So bring it. File the complaint. Go to arbitration and see. Okay? And if it gets awarded your way, fantastic. You did everything that you were supposed to do, and obviously, if it was awarded, you are entitled. Because as a result of the preponderance of the evidence, your evidence was more convincing and was more probable than not that you were due that commission. Now, again, the scenario that I gave, it was just something, don't repeat. Laura said that if you do this and you go to an open house, that the buyer is yours, it's not yours. It was just an example. So don't hold me to that one, all right? Know your ethics, know your MLS rules, know your license law. Work with one another with professional courtesy and respect. We won't have problems, okay? Or we won't have as many problems, okay? Procuring cause, and I love this, all right? Because there's meeting of the minds, which is the both parties agreeing, and there's procuring cause. So in an arbitration case, the burden of proof is on the person who's making the complaint. So they're the individual that has to prove that, hey, I was entitled to this money. I've been working with the buyer. Here's all my information. Here's this, here's that, blah, blah, everything. The burden of the proof is on that complainant. The hearing panel considers the entire course of events. And as I mentioned this before, it's not just, listen, they signed the agency disclosure form with me, they're my buyer. No, don't think so. Doesn't work that way. There is a course of events that led this buyer to this property, and how did it get to close? All right. Now, at a hearing panel, and it works both the same with ethics as it does with arbitration, I did set the setting before with letting you know that there was a chairperson, 4 panelists, legal counsel, and a staff member there. And then we have the person who's filing the complaint, the complainant, and then we have the respondent, the one who's responding to the complaint. Now, let's just give a scenario where the complainant is an agent who had the issue, but of course their broker needs to be there because this is arbitration. So there's 2 people sitting there. All right. And then on the respondent side, of course, the broker needs to be there. It's dealing with commission. But that broker could have also brought in the agent who was involved with the transaction and an attorney. Okay. They have a right to attorney. Now, the complainant can have a witness. And that witness can come to, they can, of course, evidence is submitted up front. And if you read through the forms on documents on demand, you'll see exactly the process on how it needs to be and when it should be. But all evidence is supposed to be submitted ahead of time. It's not that something cannot be presented at that given time during the hearing, but it can also be denied at that time. So a witness can be there as well. What happens is both parties have an opening statement. So the complainant will give their opening statement, and they'll just say, this is what I believe and such, right? They can give their statement. The respondent also has opportunity for a statement as well. They can also question each other. The panel members also have the authority to ask any questions to bring about clarity, to bring some things to light, not to introduce, you're not there on either half. I'm telling you, the training that we go through, they teach us about body language, everything. So it is very detailed. So there are questions that are asked just to bring about clarity on certain issues, or perhaps bring some things to light that were not clear. So there's questioning going back and forth, and everybody has an opportunity. This is all part of the due process. All right. So this is how the hearing panel gets to consider the entire course of events, because there's opening statements, there's questioning, the panel asks questions. So there's a full understanding from A to Z. How did all of this go down? How did this begin? And how did this get to the end of a closing? Now, here's the definition of procuring cause. This comes from Black's Law Dictionary, the 5th edition. And this is also noted in NAR's Guidelines of Ethics and Arbitration Manual. The definition of procuring cause is the proximate cause, the cause originating a series of events which, without break in their continuity, result in the accomplishment of a prime object. All right, so what we're looking at here is, if I was an agent that was working with the buyer, gave the buyer the listings, gave the buyer the information about the open house, sent them there. If I got that buyer pre-approved with the loan officer, if I connected that buyer with a home inspector already and an attorney, if I've been fully engaged with them without any break in continuity of what I have been doing, and they went into this open house and for some reason put the offer in through the listing agent, all right? It could be, and I'm saying could be, because the panel considers the entire course of events. So how did this originate? How did this get to this point, to this point, to this point? So what they're asking themselves is, okay, who originated? How did this originate, this series of events? Was there any break in that continuity? There's something referred to as abandonment. If I started with that buyer and then I didn't speak with them for 3 weeks, they went to the open house and then they put in the offer and they never contacted me, and all of a sudden I come out of the woodwork and say, my buyer, there was a break there. Okay, so that may not work in my favor. All right, I may not be due that commission. All right, so again, it's the cause originating a series of events which, without break in their continuity, result in the accomplishment of the prime object. And in this situation, the prime object would be the closing and a commission paid. So in other words, who is entitled to the commission? And sometimes, you know, that was an awesome description there. But sometimes a visual can give us a little better understanding of what it is when it comes to procuring cause. And I like to look at it this way. It is the broker that shakes the tree that causes the apple to fall. And it's not the one that runs up and just gathers that apple. What was the origination? What caused it? So here I am. I'm the agent. I'm the person, actually, who went up to the tree. I'm shaking the tree. And I've been shaking the tree. And I'm loosening that apple. And I got that apple ready. I pre-qualified that apple. The apple's ready to go. And I caused that apple to fall from the tree. I caused that buyer to buy, all right? Not the agent that ran up, just grabbed the apple and said, my buyer, my apple, all right? So if you have that visual too, it's the broker that shakes the tree, not the one that runs up and gathers the apples, all right? So it's that whole series, that whole course of events that the panel listens to and takes into consideration and deliberates about. So here again, matters such as the first showing of a property, the writing of a successful offer, or the exclusive of agency relationship with the buyer are not in themselves exclusive determiners of procuring cause or entitlement to a commission. So don't think, well, I got the buyer agency, I got the agency disclosure form signed. That's my buyer. Really? Maybe not. Okay, maybe not. I showed them the property first. Well, maybe not. You have to look at what is procuring cause. Now, meeting of the minds. Meeting of the minds is when price and terms are mutually agreed upon by a seller and a buyer. Listen, that could happen in 5 minutes with an agent and a buyer and a seller. Bam, it can be done. Okay, meeting of the minds is not procuring cause. Procuring cause is the party that caused the end result. Okay, a meeting of the minds not necessarily causes an end result. Very important to know the difference between the two. Okay, well, we're going to do it. I hope you got all of that and have an understanding of it and the process and how NAR dictates and lays everything out for us to follow through on these hearings. It's very important, again, for you to familiarize yourself with the Code of Ethics, and I'll throw in there our MLS rules and read agency law, read the license law, read Article 12A, advertising guidelines. It's only going to better your business. Your deals will stick. You will come out ahead and above board because your professional conduct is ahead and above board. So I do highly, highly encourage that you do that. And again, if you'd like to get involved at LIBOR on any of these committees, please, the committees are there for all of the members, of which you are. You can put your hand to this process and listen, you'll get quite educated in the middle of it as well, which again would only benefit your own business. So what we're going to look at now as we wind down, we've hit about the 2-hour mark, and we're going to wind down a bit. We're going to take a look at some of the codes within the Code of Ethics, and if time does permit, we will touch on some case studies and throw some scenarios out there to you and to see if you can kind of figure them out as to which way they would go. So again, Article 1, I did read this earlier. I'm not going to read it over again, but Article 1, which is in the first section within the Code of Ethics, deals with duties to clients and customers, and this particular article actually is very, very similar to our agency disclosure. Now, standard of practice within Article 1, I did mention this before, that a realtor in attempting to secure a listing shall not deliberately mislead the owner as to the market value. My goodness, it is a violation. Doing such would be a violation. Standard of practice 6, submittal offers. I mentioned that before. Let's go look at Article 3. Article 3 is still within the first section of the code, and it deals with duties to clients and customers. Realtors shall cooperate with other brokers, except when cooperation is not in the client's best interests. The obligation to cooperate does not include the obligation to share commissions, fees, or otherwise compensate another broker. So cooperation here, folks, does not mean you're getting compensated, all right? And it's here within the Code of Ethics that realtors shall cooperate. Now, if I cooperate with you, and here's an example, and I won't comment on it, I'm just going to say it as an example. We know on the bottom of the MLS listing, it does mention the compensation that's offered to a seller's agent, a buyer's agent, and a broker's agent. So in the event that, let's say, buyer's agent actually had 0, that means what? 0. It means there is no compensation being offered. So here's an example where I will cooperate with you, buyer agent. Fine, come on in. I'm cooperating with you. But there is no obligation that I have to share any commissions with you. Okay? It's just an example because it's something we see all of the time and we could recognize on the MLS listing. Oh, standard of practice 3-2. To be effective, any change in compensation offered for cooperating services must be communicated to the other realtor prior to the time that realtor submits an offer to purchase or lease the property. Okay? Also, I highly advise take a look at the MLS rules, because we can look at the history of things that are changing. If an agent shows a property and the commission says X, and then after they show the property, the commission was changed to Y, the commission that was posted at the time of the showing is the commission that that agent is entitled to should an offer be accepted and it go to closing. Now, what this standard of practice is giving an example or a support to Article 3 by saying, listen, if anything changes, you have to disclose. There's none of this after the fact, oh, by the way, you should have known the commission has been reduced. Okay? I like this one. This is a standard of practice 3-6. Realtors shall disclose the existence of accepted offers, including offers with unresolved contingencies, to any broker seeking cooperation. So if I call you up and I say, hi, this is Laura with ABC Realty. I'd like to show your property at 123 Elm to my buyer client. Is it still available? Yes, it is. Okay, now if that listing agent has any accepted offers or offers that are in with unresolved contingencies, like, yes, the offer is in, we're still going back and forth on terms, or it's contingent, that realtor has the obligation to disclose to me the existence of an accepted offer. It should not be that I have to ask to get that information. And that's why often it's a good practice that if you see in the remarks section on the MLS listing, if you were to put accepted offer or acceptable offer, Okay, saying something is accepted, nothing is really fine and done until the contract's signed. So also be careful of your terminology on what you're saying with that. But here it specifically says within the article, if an offer has been accepted, and that's the terminology used here in the standard of practice. Have to disclose it. Do you have any offers? Yes, I do. Have they been accepted? Yes, I have. Has a contract gone out? I need to know the status, all right? And they are obligated. And you could remind them, Article 3, Standard of Practice 3-6, you need to disclose to me. Article 10, we jumped into Section 2 of the Code, which deals with duties to the public. And this one is really all about fair housing. And this says that realtors shall not deny equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, national origin, or sexual orientation. And there was an amendment to this as well to include, I'll have to double check what I have on here with the most current printout, which is and was added. It was amended. This article was amended. At first it was amended, as we see on the bottom here, of January of 2011. It was amended again in January of 2014 to include not only, well, sexual orientation was added, but gender identity was added as an amendment to this on January in 2014. Now, don't confuse these with the protected classes, the federal protected classes, because there's federal, then you have state, and then there may be city or local protected classes. What we're talking about here is within the Code of Ethics, and it mentions sexual orientation and now gender identity. Realtors shall not be parties to any plan or agreement to discriminate against a person or persons on the same basis. All right? Realtors in their real estate employment practices shall not discriminate again against this same list of people here. It's very important for you to know your federal fair housing, the 7 protected classes, and what the state protects, and whether you're in Queens for New York City, and what the protected classes are in the counties as well. You have to know your stuff. So, standard of practice, and this is in support of Article 10. When involved in the sale or lease of a residence, realtors shall not volunteer information regarding the racial, religious, or ethnic composition of any neighborhood, nor shall they engage in any activity which may result in panic selling or blockbusting. However, realtors may provide other demographic information. Ethically, it could be a violation of Article 10. If you're volunteering information regarding the racial, religious, or ethnic composition of any neighborhood. All right, so careful, folks. Article 12, again, comes out of Section 2 of the Code, which is duties to the public. Realtors shall be honest and truthful in their real estate communications, and shall present a true picture in their advertising, marketing, and other representations. Realtors shall ensure that their status as a real estate professional is readily apparent in their advertising, marketing, and other representations, and that the recipients of all real estate communications are or have been notified that those communications are from a real estate professional. Okay, this can be pretty heavy. Honest and truthful in your real estate communications, and present a true picture in your advertising, marketing, and any other representation. True picture. So if your listing is on the border of 2 towns, but it is legally in 1 town, and one way to judge that is you go to USPS.com, the United States Postal Service, and that address is considered the address of the property. So it would be untruthful, it would not be honest, and it would be quite misleading and a misrepresentation to name that property being in the town that it is not actually in. And that also goes for school districts, anything, all right? That's a violation of the Code of Ethics. There's a violation also within Article 12A, and there's a, you're in kind of, can get yourself in trouble all around with that, all right? No misrepresentations whatsoever. Even here's a standard of practice under Article 12. Realtors shall not offer for sale or lease or advertise property without authority. When acting as listing brokers or as subagents, realtors shall not quote a price different from that agreed upon with the seller or the landlord. Be careful. That's why I'm going to tell you, even if you're out there and if you're taking an open listing, which can be the practice of some, it's not the type of listing that'll guarantee you a commission, but if you're taking an open listing, it would be very wise, and of course speak with your manager and your broker about this, to sign an open listing agreement where you are given written permission to advertise a property at a given price. All right? Be careful, because if you don't do that, and this member of the public turns around and says to you or your broker, as they're filing a complaint with LIBOR, I did not tell them that price, that is not the price, they can bring you up on, and you can wind up in an ethics hearing. And if you do not have it in writing, what are you going to do? Clear, strong, and convincing evidence. And if you don't have anything that's going to be strong, clear, and convincing, you could be found in violation. And then what will you get? Oh, maybe a letter of reprimand. You really didn't mean it, but you have something in your folder. Okay? So, read through your code of ethics, understand, and review your business practices. Article 15, duties to realtors. Realtors shall not knowingly or recklessly make false or misleading statements about other real estate professionals, their businesses, or their business practices. Need I say more? Zip of the lip. Or if you don't have anything nice to say, don't say anything at all. Article 16, duties to realtors. Realtors shall not engage in any practice or take any action inconsistent with exclusive representation or exclusive brokerage relationship agreements that other realtors have with clients. Oh, what does this mean? Well, this is also falls under, you can get in trouble there with the Department of State on this one, as well as the MLS rules. What this means, and I'll just boil it perhaps down to this, if the listing expires, and this is not the only instance for it, it's just an example, if the listing expires on the 15th of the month, that means it expires at midnight on the 15th, because the next minute becomes the 16th, and then that broker no longer has that listing contractually. If a listing expires on the 15th, it doesn't mean on the 1st of the month that you eye out the soon-to-be expired and start contacting the owner in one way or another. It says you shall not engage in any practice or take any action inconsistent with an exclusive representation or exclusive brokerage relationship agreements with other realtors have with their clients. That's on the buyer brokerage end and the seller as well. So, no. Article 16, let's look at a standard of practice. 16.6. When realtors are contacted by the client of another realtor regarding the creation of an exclusive relationship to provide the same type of service, and realtors have not directly or indirectly initiated such discussions, they may discuss the terms upon which they might enter into a future agreement, or alternatively may enter into an agreement which becomes effective upon the expiration of any existing exclusive agreement. So if the client, buyer client, seller client, reaches out to you and initiates. Wonderful. You've got no problem carrying on discussions and going in and speaking with them and emailing, texting, whatever it may be. But you cannot initiate that directly, because in accordance with this standard of practice, it gives support to to Article 16, which could be potential violation. Okay. Article 16 again gives us realtors prior to or after their relationship with their current firm is terminated shall not induce clients of their current firm to cancel exclusive contractual agreements between the client and that firm. So in other words, it's a violation, a potential violation of the Code of Ethics if you were to leave ABC Realty, go to your 3 sellers that you signed listing agreements with, get them to withdraw or release them, go over to XYZ and sign them up there. It's a code violation. Why? The listing doesn't belong to you in the first place. It belongs to the broker. Okay? So right then and there, you know, it's unfolding other sources of potential reprimand as well. Article 17, and this is the one, I read this before, so I need not do it again, but this is the one that speaks of the contractual or non-contractual disputes and about arbitration over commission. That is noted in Article 17. And again, I'll just bring out, if you are working in a transaction with a non-realtor member, they're not bound to arbitrate, and if there's an issue, they can litigate, and you could end up in court, and I don't know if that's something your broker might want to do. And it's safer to go the route by doing a sensible co-broke agreement, which would have them agree to arbitrate, should it be so. I have some case studies here. We'll just take a quick look at this, okay, as we're winding down on here. Oh wait, case 1 was, honestly, I already used it as an example. So let's look at number 2. Okay, Article 2, we're dealing with Article 2. Article 1 was the other one. We touched on Article 1 enough. This is Realtor Jeannie and Seller Leslie and Buyer Ben. And what we're going to ask ourselves is, do we think Jeannie is in violation of the code? What is Bob's obligation to the purchaser? As a hint, here's Article 2. We are to avoid exaggeration, misrepresentation, and concealment of pertinent facts about the property or the transaction. There is no obligation to discover latent defects. Do you remember what a latent defect is? It's something that's not easily discoverable or visible to the naked eye. Matters outside the scope of our license or matters confidential under agency or non-agency relationships. Now I'm going to read this case study, and then we'll take a look at who we think is a possible violation. As she always did when listing a home, Jeannie followed her checklist as she completed the property data sheet on Leslie's home. Noticing the hardwood flooring in the family room, she asked Leslie if there were hardwood floors under the wall-to-wall carpeting in the rest of the house. Leslie told her that there were. Jeannie noted that and later specified hardwood floors on the property data form. Imagine her surprise when she later received an irate phone call from Buyer Ben, the new owner. There was outrage in Ben's voice. He said, "You said there were hardwood floors in this house. Well, there's no hardwood flooring under the carpeting in the living room and in the dining room. When we took up the carpeting, we found that the bedrooms have hardwood flooring, but under the living room and the dining room, there's nothing but plywood subflooring. We paid for a home with hardwood floors. This isn't right." There's our question. Do you think Jeannie is in violation of the code, And what was Bob's obligation to the purchaser? Okay, Jeannie, according to Article 2, was supposed to avoid exaggeration, misrepresentation, and concealment of pertinent facts about the property or the transaction. Okay, was there a bit of misrepresentation? Well, it could be, because she did say, yes, they are there. So she misrepresented it in that fact. But did she actually conceal pertinent facts about the property or the transaction? She really wasn't intentionally concealing them. But then there is no obligation to discover latent defects. Now, that's something that a latent defect is something that's not visible to the naked eye. However, could she not have pulled up a corner of that carpet to see if there was, in fact, hardwood flooring there, if she was going to put it on the listing for proper representation of the listing? All right. So when you look at something like this, is it cut and dry? No, the case really isn't cut and dry, because if this was in a hearing, I would say to Jeannie as a panel member, did you consider to pull up the carpet in the corner of each room? And she may come back and say, I thought of it, but actually I just followed the owner's instruction. Or she could say, no, it was tacked down so hard, there was furniture there and the owner didn't want me. All of those things would carry weight in one way or another to see if there was potential violation of this code. She wasn't actually exaggerating, but you know what? The buyer felt that she certainly was. All right. So we see it's always a little here or there. There could always be that gray area. So just asking a question, do you think? Well, maybe I think she might be, but on the other hand, she might not be. But did Jeannie have a responsibility to verify and check everything? I personally would say so. You know why? Because if you're going to write it on the listing, you should know it's there. All right. So, but we don't know how this would pan out with a panel. So these case studies are very interesting. And I'll be honest with you, they do not say yay or nay, because then what would happen in that particular situation, if you had a similar situation to the case study, anybody could be led to believe, oh yes, the case study says it is a violation. But everything, remember, there is due process, and that is the purpose for is due process. I do want to say thank you so very much for tuning in. You are fulfilling your obligation as mandated by NAR for the required 2.5 hours. I will again leave with these parting words, but will again say, please do read the Code of Ethics and take it even further and read through the MLS rules and regulations and go through real property law, license law, agency law, and Article 12A, which is all included within there. It will better your business. You'll be a stronger, even perhaps, of course, more ethical and better professional. So thank you all so much. On behalf of LIBOR, I do thank you. And I wish you all a productive and ethical real estate career. Thank you so very much.